Hello everyone and welcome back to the lecture series for the preparation of CLAT examination. In this particular lecture series, we are discussing about the important aspects of legal reasoning, the important part of the syllabus of your CLAT examination. In the previous lecture series, we were talking about the election commission and how the election has to take place in the country. And today we are going to discuss about the emergency provisions in regards to the Constitution of India. As you already know that when you're preparing for CLAT examination, there are different areas which one has to cover in order to make sure that once they have been acquainted by the syllabus and once they have acquired the knowledge which is required to clear this examination, it becomes perhaps easier after obviously rigorous practices that you will be able to understand that what exactly is the pattern of the question paper and what are the things that is going to be asked in your question paper as such. So if we go in the detailed description as to how the examination takes place in regards to CLAT, the provisions that are often being asked is considered to be the important provisions, and this is how what is we are discussing in this particular lecture series. We are focusing over the important provisions of the different legislations, be it the constitution, be it the family law, all the things that has been asked and in the previous years question papers of CLAT examination. And also what the syllabus says about the legal reasoning portion of your CLAT examination. We are just focusing over that, and we are trying to understand that what exactly are these provisions, trying to understand what exactly the constitution said, what exactly the penal law says, what exactly the family law says, what exactly the different legislations that has been created by the parliament and the state legislatures, both what their statements are. That is something that we need to understand. And that is perhaps the reason we have been going through this lecture series. So coming back to the lecture, we are going to discuss emergency provisions today. So when we talk about emergency provisions, first we need to understand that what is the relevance of emergency provision. So emergency provisions, if we talk, first and foremost, what do you understand by emergency? Emergency means a situation, alarming situation. We can write down it like this, that it is an alarming situation. Alarming situation which causes disruption or disturbance in the normal progress in the society. So you must have heard that in the past we had a emergency that was put up in the year of 1975. It was a national emergency. Then there are different type of emergencies also according to the constitution. Okay, we are going to discuss that. But obviously first we need to understand what exactly emergency means. So emergency is nothing but is it an alarming situation which causes disturbance in the normal progress of the society. So obviously there will be a time, or there will be a moment where because of different reasons, it can be anything. It can be because of external disturbances. Maybe some country have attacked on India. Let's take an example. If somebody attacks on India, then obviously it will be an emergency situation. For example, the government, which is the ruling party, is not able to progress, or has been considered that this party is corrupt. Okay, and now a no confidence motion has been passed against it. Then obviously there will be an emergency situation that will be declared. And for example, if the finances are such low that because of which you must have heard recently there was a financial emergency that was put up in the country Sri Lanka. So that is why it becomes important to understand what exactly the constitution is saying about the provisions which is in relation to the emergency. When emergency will be there, what will happen, how will happen, and how the emergency will be proclaimed, who is authorized to proclaim the emergency. All these points becomes very important for discussion in regards to your CLAT examinations, because obviously there will be questions that will be put up in regards to emergency provision that is in that has been mentioned under the Constitution of India. So in this lecture series, we are going to discuss those emergency provisions. As you can see on the screen, part 18 of Constitution suggests provisions relating to emergency. So let's try to understand what exactly these provisions are saying. So as you can see on the screen, I suppose the screen is visible to you all. The emergency provision starts with the Article 352. This is Article 352. This proclamation of emergency provides that how and when the emergency can be proclaimed. Proclaim means it can be applied. Okay. So it says that if the president is satisfied that a grave emergency exists. Okay. If the president, okay. So as you know that president is what? President is a nominal head. Nominal head which is going to work on the aid and advice of Council of Ministers. And Council of Ministers are whom? Our Council of Ministers are those ministers who are the member of parliaments who have been given certain portfolios, whether be it agriculture, whether be it railways, etc., finance, home ministry, etc. And once they have provided that aid and assistance to the president, and president is satisfied by the aid and advice of the Council of Ministers that there is a grave emergency. So what is the main reason of explaining that instead of president it is the aid and advice? That obviously president is, or whenever you will be reading the provisions of the Constitution, you will be seeing that there is a lot of mentioning of the president, but there must be a confusion in the mind of the readers and obviously the students that so president is considered to be the nominal head. Then there are lot of provisions which says that the president is going to do this and the president is going to do that. So whether it is actually the president who is going to do that, or it is by the aid and advice only he is going to work. So the answer here is it is only through the aid and advice. The president is not going to do anything. It is rather after it is aided and advised by the Council of Ministers that this thing has to be done, the president is going to do that particular thing. So basically he is, in the name of the president, every work and everything will be done, but he will be aided and advised by the Council of Ministers. The Council of Ministers, which consists of the Prime Ministers and obviously all those ministers who are holding important portfolios, in example, agriculture, railways, finance, etc. Okay, so it is the president who is going to do it, but obviously through the aid and advice of the Council of Ministers. So if the president is satisfied that a grave emergency exists, whereby the security of India or of any part of the territory thereof is threatened, whether by war or external aggression or by armed rebellion. First, initially there was no armed rebellion, now it has been added. He may, by proclamation, make a declaration to that effect. Now, this particular armed rebellion has been changed and it has been named as internal differences. Internal disturbances can be anything. It can be in regards to corruption, in regards to riots, etc. Whatsoever happens because of which the normal functioning of the government as well as the society is not able to take place, then, and if it is satisfied in the eyes of the president, namely in the eyes of the Council of Ministers and the Prime Ministers, that there is a reason to apply emergency, then obviously the emergency can be applied. But the grounds that has been clearly mentioned is whether by war or external aggression or by armed rebellion. So whether it is actually the president who is going to do it, external aggression, or armed rebellion, which has been considered to internal disturbances. Now, I would like to tell you that there are three types of emergencies if you talk about in layman language. The first, obviously, is external aggression. Okay, if there is attack by the country or foreign countries over India, then obviously it will be considered as external aggression. Second is internal disturbances. And the third one is financial emergency. What we need to understand here is that external aggression, internal disturbances, and financial emergency are three main grounds on which emergency can be proclaimed. And one has to understand that what exactly external aggression is, what exactly internal disturbances, and what exactly financial emergency is. External aggression, obviously I just informed you. Internal disturbance, it can be on both the sides. It can be on state level also, and it can be on central level also. For example, if the state government, let's take the example of Uttar Pradesh. If the state government is not able to work to the best of its limit, or it has come to the knowledge that the state government is involved in corrupt practices, or a vote of no confidence motion has been passed against the state government, in that point of time, there will be a situation which there will be no government as such. So when there will be no government, it will be considered that the state has no governing authority. At that point of time, it will be considered that it is something which has caused internal disturbances. And internal disturbances will result in the proclamation of emergency. And the third one is financial emergency. When the state machinery is not able to work because of less funds, the same which happened in Sri Lanka, that type of emergency is known as financial emergency. So here what we need to understand is that who is going to proclaim, who is going to apply the emergency? It is by the president itself. But president is obviously, not himself, he is going to act. It is on the aid and advice of the president, aid and advice of Council of Ministers, that he is supposed to work. Okay, so this is emergency provisions. Now, a proclamation of emergency declaring that the security of India or any part of the territory thereof is threatened by war or external aggression or by armed rebellion may be made before the actual occurrence of the war or of any such aggression or rebellion if the president is satisfied that there is an imminent danger thereof. Okay, so it means that it is not like that only after the war has been done, war has started, then only the emergency will be proclaimed. No, if there is even threats that there are high chances that that there will be an attack by the external aggressions by the foreign countries, or maybe by any foreign elements, then at that point of time, it is, if the president is satisfied, he can still apply emergency at that point of time. Okay, and that the president shall not issue a proclamation under the clause 1 or proclamation varying under such proclamation unless decision of the union cabinet, just I was informed you, that is to say the council of ministers consisting of the prime minister and the other ministers of the cabinet rank appointed under article 75, that such a proclamation may be issued has been communicated to him in writing. I just informed you that it is not directly by the president who is going to proclaim the emergency. It is rather by the cabinet ministers, or if I'll say the council of ministers consisting of the prime ministers and the other ministers. He is going to proclaim that emergency once it has been communicated to him or her by writing. Okay, this is important portion. Every proclamation issued under this article shall be laid down before each house of the parliament. That is, what is the two houses? One is the Lok Sabha and the second one is Rajya Sabha. And shall accept where a proclamation revoking a previous proclamation cease to operate at the expiration of 1 month, unless before the expiration of that period, it has been approved by resolution of both the houses. For example, I'll give you an example for a better understanding here. Let's take the example that on 1/10/2020, okay, 1/10/2020, emergency was proclaimed. Emergency was proclaimed, okay. And then at that point of time itself, the union ministers, union cabinet gave in writing to the president that you proclaim emergency, okay, that you proclaim emergency. Now, after that, each proclamation issued, now issuance has been done under this article, shall be laid before each house of the parliament, and shall, except where it is a proclamation revoking a previous proclamation, cease to operate at the expiration of 1 month, unless before expiration of that period has been approved by the resolution of both the houses. It will be presented into the Lok Sabha, that is the lower house, and the upper house, that is Rajya Sabha. And then both the houses, the houses of the parliament, shall decide whether this particular proclamation should continue or it should not continue. If they have provided with the resolution that this particular emergency should continue, then it shall continue till the time it has not been revoked. Else, if the resolution says that we are not going to continue with the emergency, then it will by itself expire. It will by itself expire after 1 month, unless before the expiration of that period it has approved by the resolution of both houses of the parliament. So it will expire after 1 month. If it has been approved by the parliament, obviously it will continue. But if it has been not approved, then it will expire by itself, by default, after 1 month. This is what the provision is saying. Provided that if any such proclamation, again, not being a proclamation revoking a previous proclamation, so if we want to issue an emergency, then also we have to proclaim. When we are revoking the emergency, then also we have to proclaim. So the second line, it is actually saying if they have already applied an emergency and now we want to revoke it, then we are proclaiming it. It is about that. But right now you do not discuss that. Let's try to understand what exactly the provision is saying. It is saying that provided that if any such proclamation is issued at the time when the House of the People has been dissolved, okay, or dissolution of the House of the People takes place during the period of 1 month referred to in this clause. Okay, in the previous clause we have read, for example, on 1/10/2022, it was proclamation of emergency, and during this time period, Lok Sabha got dissolved. Lok Sabha got dissolved. Okay, now then what will happen? During the period of 1 month referred to in clause, and if the resolution approving the proclamation has been passed by the Council of State, but no resolution with respect to such proclamation has been passed by the House of the People, before the expiration of that period, the proclamation shall cease to operate at the expiration of 30 days from the date on which the House of the People first sits after its reconstitution, unless the expiration of the said period of 30 days, a resolution approving the proclamation has also been passed. Okay. Now, 1/10/2020, issuance of emergency took place. Okay. How the emergency takes place? It is through the president itself. The president is going to apply the emergency by the aid and advice of the Council of Ministers. Once he has issued the emergency, it will be put forward in front of the Lok Sabha and the Rajya Sabha to have discussions whether this particular emergency should be extended or not. At that point of time, if they approve it, then the emergency continues. Emergency continues. If they disapprove it, then after 1 month, it expires. After 1 month, it expires. Now, let's take one more consideration here, which has been mentioned in this particular paragraph. That once that emergency has been proclaimed, Lok Sabha is dissolved. Dissolved means it is not in working. It is not working. And Rajya Sabha has approved it, approved the emergency. Whether the emergency shall continue, emergency will continue till the time that the House of the People again sits. And once they sit, they have a time period of 30 days. And if they have approved the emergency after they sit back, after the dissolution, they come back to the house and they start again working. And post that, if they see through it that yes, this emergency needs to continue, then they will approve it, and obviously the emergency shall continue. If they don't approve it, then on the date on which the Lok Sabha sits, starting date till 30 days, the emergency shall continue, and then it will dissolve. It will removed. It will be removed. Okay, this is what this section is saying. A proclamation so approved shall, unless revoked, cease to operate on the expiration of a period of 6 months from the days of the passing of the second resolution approving the proclamation under clause. Okay, so a maximum period for emergency shall be 6 months. Any emergency, whether it has been approved, not approved, if it is not approved, obviously after 1 month it is going to dissolve. Okay, it is going to be removed. But if by any chance possible that the Lok Sabha is not in session, the Lok Sabha has been dissolved, okay, and there is no action that has been taken by the parliament in regards to the issuance of emergency. So a total period, a maximum period of 6 months is the time where which the emergency shall continue. Post that, the emergency by itself end. So it is a very important point to remember for a CLAT examination point of view, that it is only for 6 months, a maximum period of 6 months, that emergency can be proclaimed. Provided that, if so, and often as a resolution approving the continuance in force of such proclamation is passed by both the houses of the parliament, the proclamation shall, unless revoked, continue in force for further period of 6 months from the date on which it would otherwise have ceased to operate under this clause. Now, if the Lok Sabha or the lower house and Rajya Sabha upper house, if both of them approves for extension once proclamation has been continued, then it can again be extended for a maximum period of 6 months only. Okay. House of the Parliament, the proclamation under revoked continue in force for a further period of 6 months from the date on which it would have otherwise been ceased to operate under this clause. Okay. Provided further that if the dissolution of the House of the People takes place during the said period of during any such period of 6 months and a resolution approving the continuance in force of such proclamation has been passed by the Council of States, but no resolution with respect to the continuation in force of such proclamation has been passed by the House of the People during the said period, the proclamation shall cease to operate at the expiration of 30 days from the date. The same thing will continue, and the House of, unless revoked during the said period of 30 days. A resolution approving the continuation in force of the proclamation has been passed by the House of the People. So let's try to summarize so that it becomes very clear to you that how the emergency will take place. For example, 1st of June 2000, again I'm giving you a new date so that it becomes clear. 1st of June, President decides, 1st June 2024, President decides emergency to take place. Emergency issued. Then the issuance of emergency is going to be discussed in the Parliament, both Lok Sabha and Rajya Sabha. Lok Sabha and Rajya Sabha disapproves the emergency and says that this emergency should not continue. Okay. after 1 month time duration from the date on which the emergency was issued, it will by default be discontinued. Okay, it will be removed. Okay, normal continuation will take place. If after the issuance of emergency, the Rajya Sabha approves it. Okay, Rajya Sabha approves it, that saying that okay, fine, we are okay, an emergency should be proclaimed. Lok Sabha is not in motion. So Lok Sabha, until that time period, since the Lok Sabha is not in motion, the emergency shall continue. Okay, emergency shall continue, and it will by default be, once the House of the People will come into play, they will see to it whether the proclamation should be given or not. If they proclaim, and that proclamation, until unless the House of the People is reconstituted, it will continue to a total span of 6 months. Okay. Before that, if the House of the People reconstitutes, okay, 1 month before, after the initial period of 1 month, the Lok Sabha again continues. Okay, Lok Sabha comes back. At that point of time, Lok Sabha and Rajya Sabha both approves it. Then, from the date of the issuance of the proclamation, it will continue to the period of 6 months. And after that, it will cease to operate. If, until unless, again issuance has, again, both the parliament, the houses of the parliament, the Lok Sabha and the Rajya Sabha sits together and they decides that it is necessary for the benefits of the society that the emergency should continue. Then it can further continue for a period of 6 months. Okay. And then if during that 6 months, emergency is seen that okay, now the house has been dissolved, the emergency is continuing. 6 months emergency is still continuing. And again, there was an issuance by the government, by the president, saying that it is necessary to further start the emergency. Okay, so that point of time, it is by the declaration, and if the House of the People is not there and it's still approved, then again it will only continue till a period of 30 days, not more than that. This is how the whole emergency is going to take place and how the emergency will continue and it will cease to operate once these particular provisions are to be understood. Okay. For the purpose of clause 4 and 5, a resolution may be passed by either House of the Parliament only by a majority of total membership of the House and a majority of not less than 2/3 of the members of the House present and voting. So it should be majority of total membership So for example, if you have 550 members, then 226 members should be there should be total members of 226 and the majority of not less than. So now there should be 226 votes approving the issuance of emergency. Issuance of emergency. Okay. And once they have approved it, then the members present on the date on which that issuance has taken place. Issuance took place by 2/3 majority of the total house of the house. It has been decided that yes, proclamation should continue. Then the proclamation shall continue. Else, if the house has not given, then it will by default be understood that they have disapproved it, and then by default that 1 month time period will only be taken into consideration. Notwithstanding anything contained in the foregoing clauses, the President shall revoke a proclamation unless under clause 1 or the proclamation bearing such proclamation, if the House of the People passes a resolution disapproving, or as the case may be, disapproving the continuance in force of such proclamation. So if the Lok Sabha, if the lower house says that this proclamation should not continue and cease to continue, so at that point of time itself, the proclamation shall stop. Where a notice in writing signed by not less than 1/10 of the total numbers of the members of the House of the People has given of their intention to move a resolution of disapproving, or as the case may be, for disapproving the continuation of force of the proclamation under the clause, or a proclamation varying such proclamation, to the Speaker if the House is in session, to the President if the House is not in session. A special sitting of the House shall be held within 14 days from the date on which such notice is received, and as the case may be, by the President for the purpose of considering such resolution. So now if the lower house says that, okay, we should not continue, then immediately within 14 days the meeting needs to be held. Why? Because the emergency is continuing. So once you need to stop the emergency, what do you do? You need to ask the relevant houses to come back in the session, and then you discuss it, and then you approve or disapprove it. If they say that, no, I don't want to, the house says, lower house says that we don't want that the emergency should continue. So at that point of time, they will send a notice to the President as well as to the Speaker of the House if they are in session, disapproving that proclamation, and immediately a special sitting will be held in which within 14 days that meeting needs to be held, and that in that meeting it will be decided whether that proclamation should continue or should cease to exist. Okay. The power conferred on the President by this article shall include the powers to issue different proclamation on different grounds, being for external aggression or armed rebellion or immediate danger or of war or external aggression, whether or not there is a proclamation already issued by the President under clause 1 and such proclamation is in operation. So it means that it is not like that if there is one emergency, then only that emergency will be there and another emergency cannot be put up. If you have if the country is going through external aggressions, then the emergency has been put on the basis of external aggressions. But at that point of time, it comes to the knowledge that there is internal disturbances also, or there is financial emergency also. So another emergency will be operational without touching the previous emergency which is already in force. So it will not affect the proclamation or the emergency which is already existence, and the President has the authority to issue another proclamation on the different ground of emergency. That is what has been mentioned in this particular clause. Okay, so we have understood Article 352, which is talking about the proclamation of emergency, which is perhaps very important because it is explaining you the whole procedure, how the emergency needs to take place. Now we are coming to the sub clauses or the clauses which are going to support the main clause of section 352, which is talking about the emergency provisions. Let's try to understand what exactly 353 is saying. It is saying effect of proclamation of emergency. When a proclamation of emergency is operational, notwithstanding anything in this constitution, the executive powers of the union shall extend to the giving of the direction to any state as to the matter in which executive power thereof has been exercised. For example, state Uttar Pradesh, emergency. Then who is going to take care about the governance? It is through the union government. Union government means the government, NDA government, headed by okay. So this is how it has to be. So if the state government is not into functioning, then the central government, the union government, the cabinet, the executive powers of the union, okay, shall extend to the directions to any state as to the matter in which the executive power thereof has to be exercised. The power of the parliament to make laws with respect to any matter shall include powers to make laws conferring powers and imposing duties and authorities. So all these powers shall be vested in the hands of the parliament, and the parliament is going to decide that what are the rules and regulations that has been enumerated at the union or officers and authorities of the union in respect to that matter, notwithstanding that it is one which is not enumerated in the union list. So it is irrelevant whether it has been mentioned in the union list or not. Union list is that list on which only the union government is supposed to make the laws. But if during the emergency there is a need, that the state government is not into functioning and there is a emergency that has been declared. So at that point of time, the union government can govern that particular state also. This is what has been mentioned in Article 353. That is more than enough for you to understand what is 353. There is nothing which should be more helpful and more valuable if you talk about CLAT examination as such. That is more than sufficient for you to understand that there is a 6 months duration. When is there a 6 month duration? When is 1 month duration? And there is obviously a question that has been put up in your CLAT examination n number of times, that what is the longest period till which the emergency can be declared. Okay, so longest period till which the emergency can be declared, maximum period is 6 months. Remember this. And it can be reissued. It can be reissued for another 6 months. Now, there is one clause. There is one catch here for you to catch it. If it has been approved, then it will be maximum period of 6 months. If it has not been approved, then it will cease to operate after 1 month. So this is a different set altogether which you need to understand, that if the issuance of emergency has been accepted by the parliament, then it will extend to a maximum period of 6 months and then it can be reissued for another 6 months. And this process can continue. It is not like that it will stop after 6 months and 6 months. It will continue until unless it is clear that now there is no need of emergency to be proclaimed. But maximum period at one go is 6 months if it is approved. Maximum period if it has not been approved, 1 month. This is what you need to remember. Who is going to proclaim emergency? It is the president who is going to proclaim the emergency. On what? Once it has been issued by the cabinet ministers, that is the council of ministers along with the prime ministers, that such proclamation needs to be addressed and it has been given to the president in writing. So this is how the whole emergency shall take place. Now, application of provisions related to distribution of revenues when a proclamation of emergency, this is something which is not important for you, so we will be skipping it. Duty of the union to protect states against external aggression and internal disturbances. So it is the duty of the union. So it shall be the duty of the union to protect every state against external aggression and internal disturbances and to ensure that the government of every state is carried on in accordance to the provision of the constitution. So as you know that India, that is Bharat, is what? Shall be a union of state. Shall be a union of state. So it is the duty of the union. It is the duty of the union to make sure that there shouldn't be any external disturbance or internal disturbances, and the state machinery, the state governance is being carried out according to the provisions of the government or according to the provisions of the constitution. So this is the duty of the union. If at all there is any external disturbances or internal disturbances, at that point of time, obviously the union government will take into consideration the whole governance and it will direct how the governance needs to take place. But it is also the duty of the union or the central government to make sure that these external disturbance or internal disturbance never take place at the first time. So who is responsible for the same? It is the duty of the union. Important for you? Not that important, but yeah, this is important. This is provisions in case of failure of constitutional machineries in the state. Now, if the constitutional machinery of the state is not able to function, which is internal disturbances. If the president on the receipt of the report from the governor, now the governor is going to explain to the president that there is a situation where which the state government is not able to function and you are advised from our side that you should proclaim emergency. Or if the state or otherwise is satisfied that a situation has arisen in which the government of the state cannot be the government of the state cannot be carried on in accordance with the provision of the constitution, the president may proclaim what? Emergency. Okay, this is important portion for you, that if the government state government is not able to function properly, and the governor is of the belief that the government is not able to function properly, then they will advise, he will send a report to the president stating that the government is not able to function, and the president shall proclaim emergency. Okay. Declare that the power of the legislatures of the state shall be exercised or authorized by the parliament. Obviously, the powers shall come into the hands of the union, that is central level. Makes such incidental or consequential provision not important for you, so we'll be skipping that particular portion also. This already we have informed. Every information shall be laid down. Now, the same thing that we have studied, but instead of 1 month, if we're talking about proclamation of emergency in regards to the state, it will cease to exist after 2 months. In the union one, we were studied, it was only 1 month, but when you talk about state emergency, it will be 2 months. But the same process shall continue. It is the same process that we have studied. Okay, 2 months. The same one, same thing. Everything that we have studied under Article 352, it is the same provision, but instead of that 1 month time duration, it has mentioned 2 months. Rest, everything is the same. Everything is same. 2 months referred to in clause 1 and is passing, but no resolution is passed. On a period of 6 months from the date of his issuance. That is the same. Okay. The same thing will continue, but instead of 1 month, it will be 2 months. Instead of Lok Sabha, it will be the Vidhan Sabha or the Legislative Assembly, and instead of Rajya Sabha or the Upper House, it will be Legislative Council. The same things will be there in regards to Article 356. It is just about talking about that same thing. Okay, this is it in regards to internal emergency. A proclamation of emergency is in operation in the whole of India. The case may be in the whole of India. Okay, this is clause 5. Notwithstanding anything contained in clause 4, which is talking about the proclamation of an emergency with respect to the continuation of force of proclamation approved by the clause, for a period of expiring beyond the expiration of 1 year from the date of issuance of such proclamation shall not be passed by either house of the parliament unless a proclamation of emergency is in operation in the whole of India, or as the case may be, in the whole or any part of the state at the time of the passing of the resolution. Okay, so it will not go beyond 1 year. For state emergency, it cannot go beyond 1 year. For national emergency, it can go for a maximum period of 6 months only. Okay, that is it. Now, exercise of legislative power and the proclamation issued in under 356. So let's try to understand who will be having the legislative powers. It shall be held in the hand of the union, where by proclamation issued under clause 1 of this, it has been declared that the powers of the legislature of the state shall be exercised by or under the authority of the parliament, that is the Lok Sabha and the Rajya Sabha. It shall be competent for the parliament to confer on the president the power of the legislatures of the state to make laws and to authorize the parliament to derogate subject to such conditions as he may think fit to impose the power so conferred to any other authority to be specified by him in this behalf. For the parliament or the president or other authority in whom such power is to make the laws is vested under subclause A to make laws conferring powers and imposing duties or authorizing the conferring of powers and to imposition of the duties upon the union of the officers and authorize thereof. So basically, in short, what it is saying is that whenever there is such type of emergency will take place, the union government shall take over and the parliament will make the laws. The union government will direct how the work has to be done instead of the state government working on regards to the same. Rest, everything is same. Suspension of provisions of Article 19 during emergency. This is very important. Whenever there is an emergency, proclamation of emergency take place during because of war, external exertion, etc., then Article 19, that is your fundamental freedom, shall cease to operate and it shall not be applicable. Nothing in article shall restrict the power of the state as defined under Part 3 to make any law or to take any executive action which the state would, but for the provision contained in this part, be competent to make or to take But any law so made shall, to the extent of the incompetency, cease to have effect as soon as the proclamation cease to operate, except as respect that things be omitted to be done or before the law cease to operate. It means that the moment the operation of emergency ceases to exist, in the same point of time, Article 19 will again come into play and the restrictions shall be removed from Article 19. Okay, provided that where such proclamation of emergency is operational only in any part of the territory of India, any law may be made or any such executive action may be taken under this article in relation to or in any state or union territory in which or in any part on which the proclamation of emergency is not in operation, if and in so far as the security of India or in any part of the territory thereof is threatened by the activities or in relations to a part of the territory in which the proclamation of emergency is operation. For example, this is Uttar Pradesh, this is Delhi, okay, this is Madhya Pradesh. UP emergency proclamation is taking place, okay. Now it is sharing boundaries with Madhya Pradesh and Delhi. It feels like that there can be chances of influence or attacks or any sort of disturbance in the states of Madhya Pradesh as well as in the state of Delhi. So for that manner, the suspension of Article 19 can be taken place in Madhya Pradesh as well as in Delhi if it is assumed that if it is seen that the internal disturbance that is taking place is threatened, has to that extent causes the security to be threatened in the part of the territories which is adjacent to the emergency provisions which has already been in operation. Okay. To any law which does not contain any recital of the effect of the proclamation of emergency is made to the executant actions. No, that is not important for you. Now, suspension of enforcement of rights conferred by Part 3 during emergency. When a proclamation of emergency is in operation, the President may by order declare that the right to move in any court for the enforcement of such rights conferred except Article 20 to 21 as may be mentioned in the order, and all proceedings pending in any court for the enforcement of the rights so mentioned shall remain suspended for the period during which the proclamation is enforced or for such shorter period as may be specified in the order. So if they are going for the enforcement of right that has been conferred under Part 3 except from Article 20 and 21, which is talking about right against arrest and second being the right to life. Any article which you want to enforce, for example, your right to equality has been right to equality has been suspended. Okay, you are not able to enforce your right to equality, and emergency is being proclaimed in that particular area. So if you want that the particular proclamation, okay, and you want to move to the court for the enforcement of those particular rights, that will be suspended until unless the proclamation ceases to exist. Once the proclamation has ceased to exist, then obviously your enforcement of the rights shall take place. Okay, that is what the main scenario here is. Now the last portion, the last article, which is talking about the provisions as to financial emergency. If the President is satisfied that the situation has arisen whereby the financial stability or credit of India or any part of the territory thereof is threatened, he may, by a proclamation, may declare to that effect. Okay. And it will extend till a period of 2 months if it has not been approved. It has been approved, then it will continue. Okay. This is 30 days, the same scenario. Okay. The same one, the Article 352, whichsoever we have studied. And during the emergency, it can also cause what? Reduction in the salary and allowance of all the class of the persons serving in connection with the affairs of the state. A provision requiring all money bills or other bills to be, the provisions of RDA applied to be reserved for the consideration of the President after they have been passed by the legislature. So these are the two important points that you need to remember during the emergency. Financial emergency, reduction in salary, and suspension of consideration of money bill. If at all these money bills has been passed, then these will not be considered to be Understood. So this is what is the main scenario and what are the main conditions in regards to the emergency provisions. We have discussed three provisions altogether. One, we have studied the external aggression. Second, we have studied in regards to the state machinery, internal disturbances that take place. And the third one being the financial emergency. All these emergencies has perhaps the same process, only the duration has been different. The provisions that we talked about under Article 352, which is talking about the external aggression or armed rebellion emergency, which has been proclaimed throughout the country. The maximum time period through which it can be extended is 6 months. Minimum time period, if it has been approved by the parliament, is 1 month. If you talk about internal disturbances or state machinery breakdown because of which the emergency has taken place, if it has been approved, it can go up to a maximum period of 1 year. And if it has not been approved, it will cease to operate after 2 months. And same goes for the financial emergency also. So with this, we have completed the emergency provisions of the Constitution also. We have tried to explain that what are the important provisions and how the emergency takes place in India, and how the president is being authorized to proclaim the emergency, and obviously on the aid and advice of the Council of Ministers and the Union Ministers only, they will be working and aiding and applying the emergencies as such. I suppose you were able to understand the provisions of the emergency in a crisp, clear and crystal manner. I would advise you that you revise it, and after revising it, you go through the previous year question papers and check that how the emergency questions has been put up in paragraphical forms, and you've been asked questions in regards to the same. Once you will acquire the knowledge of how the questions has been put up in the CLAT examinations and understanding the provisions which I've just informed you, just explained to you, applying the principles which we have understood right now, taking into consideration the format in which the questions will be presented to you. Once you practice both the things together, you will be able to answer any question which is in relations to the emergency provision that will be put up in front of you in your CLAT examination. And I suppose you were able to understand these provisions in a very clear manner. With this, I would again like to thank you all for being present in this lecture series. In the upcoming lecture, we are going to discuss about the amendment procedure and how the amendment of the Constitution take place, what are the rules and regulations in regards to the same, and then obviously we will be continuing with the other relevant portions of your legal reasoning sections. With this, I would like to thank you all for being present in this video. Till then, take care.